Today we're going to spend some time talking about the Dynamex ruling and sort of its impact in California and across the nation. And I think it'll take about 45 to 50 minutes, so if you have questions, there'll be room at the end or in the midst, and please participate in the polls. So today's agenda will be covering a brief snapshot of what the independent workforce looks like now in light of some recent reporting. Rob will take us through the Dynamex ruling and how it affects various parts of the country, most specifically in California. And then we'll be wrapping up with some key takeaways and concerns that you guys can take back to your own organizations. And then finally, we'll wrap up with some Q&A. So on Thursday of last week, the Department of Labor released a report on the independent workforce. And there's just a couple of key takeaways from that we wanted to share with you guys. First, that there are about 10 million people who had alternative work arrangements. Now, recognize that 10 million people that they're referring to there is those folks who self-identified as having alternative work arrangements as their primary income. So we juxtapose that information with other sources of data from various surveys over the last year, which estimates that the total number of folks not working in a regular full-time job is more like 44 million, and therefore 29% of the U.S. workforce. Rob, did you want to add something?
Yeah, thanks, Neil. And I think some of the key takeaways here in looking at the recent BLS report, they found that there were about 10 million people who classify themselves as independent contractors, according to that study. That's about 6.9%. Now, the interesting thing is it looked like the independent contractor stats had gone down or really hadn't moved much since 2005, the last time they did this. Without going too deep into it, there have been some questions about the methodology and the reporting. One thing to note in those statistics, which seem to go against what Neil was mentioning, these independent reports, one thing to note is that the BLS did have 4 questions that were aimed at app-based, on-demand kind of gigs, and those 4 questions were not included in these statistics. The other thing to note as well, which might bring not into question, but add a little nuance to their methodology and to the statistics, is that the people who responded here to the BLS questions were just responding for their primary source of income. And as we know, that would leave out a lot of people who moonlight or freelance or do something on the side to supplement their income and are paid on a 1099 basis. So those people, that segment of the economy is not included. So I think it's a couple important details there.
The other thing I would point out before we move on is that this took a 1-week snapshot. So if for whatever reason the respondent hadn't worked in their side gig during the past week, it wouldn't have shown up at all. All right. So, but what's the real takeaway here? So if we look at what employers want and what workers want, so what we wanted to point out here is that regardless of the BLS stats and et cetera, we have seen, and this is a trend that's been continuing, that workers want alternatives to full-time employment. What that means is they want to control their own life. They want to control their own schedule. They want to control their own employment brand. Similarly, employers want variable versus fixed costs, and this is leading to an increase, we perceive an increase, in the number of people who are working either full-time, either freelancing as a primary source of income, or doing side gigs, sort of like Uber. At this point, I think we're going to take a little bit of an audience poll just to gauge how folks perceive the next section of our presentation, which is the Dynamex ruling. Holly?
Thanks so much. And so, guys, this is our first poll of this webcast. And so the question at hand right now: how do you believe the new Dynamex ruling may impact your independent workforce strategy? Would you say that it's A, it makes it easier to find and manage talent? Would you say that it actually makes it harder? There's no impact? Or maybe you're not sure, and so if you'll go ahead and put your responses into that polling widget to the left of the video player, we'll go ahead and hop over to those results. So it looks like a lot of uncertainty to start out with. So Rob and Neil, what do you guys think about that?
That's commensurate with what's going on right now. It is a world full of uncertainty that we're gonna dive into. I think we're seeing, too, some of the stats move up for making it harder to find and manage talent. Yeah, I mean, that's connected to the uncertainty, but there's certainly a lot of trepidation out here about, well, what do we do, now? So we hope to clear some of that up, but of course, there is still going to be uncertainty for a while to come in California over this.
Yeah, I would agree, Rob. I think as I'm watching this poll moving in real time, the not sure is by far the most common response, and honestly, I think that's a reasonable response to what we're going to discuss here for the next 10 or 15 minutes.
That sounds like a great opportunity to provide more information on that Dynamex ruling, and so we'll go ahead and get back to the presentation and dive right in.
All right. Yeah, that's great. So, I mean, we're here to talk about Dynamex and the ruling. I think a lot is known about this already. So as we, move ahead here to the next slide, Holly, we'll kind of dive in. I think the specifics of the case are important, but less important than what happened, which is the new California Supreme Court test that came out of it. A few of the specifics, however, are that the plaintiffs here were delivery drivers for Dynamex on-demand, same-day delivery service. And they went back and forth between a couple courts on what standard to use to determine whether they were employees or independent contractors. In California previously, for decades, we had the Borrello test, a multi-factor, totality of the circumstances kind of review to see whether someone was classified properly. The court, ultimately the Supreme Court chose to go away from that, and that's a huge departure, and chose to adopt this California version of the ABC test. The ABC test has existed in other states, but here's how it came out here. I think another thing to say too, a couple points, is this decision here applies specifically to this case. We're going to talk a little bit more about that. And this case had to deal with a wage orders. And those govern things like meal, rest breaks, things like that. But even though we're talking about just this specific case here, what's really looking like it's going to happen is that this test is going to be used at least throughout the state and far beyond just wage orders. So, what is the ABC test? Now it's on the employer. The burden is on the hiring entity now to prove that they've classified correctly. And they need to prove it by satisfying each of these three prongs here. So the first is that the worker is free from control and direction under the contract. And in fact, this is something that Borrello had already covered. This is more like the control and right to control test. And this just the takeaway here is that if you have an independent contractor agreement and it looks great and ironclad and does set out the parameters properly and compliantly, that's the contract part. Make sure you're adhering to that. What sometimes we see is that there's an ICA that gets signed by clients, it gets signed by contractors, and nobody knows what's in it. And regardless of what's in it, the project is directed or controlled, however it's directed or controlled. So this part about under contract, and in fact, becomes important because you need to be, practicing what you're preaching. You need to be making sure that everyone understands what's in that ICA and that everyone adheres to it. I'll skip to the third, which is prong C, that the worker is customarily engaged in the independently established business. Again, this is something that's been around for a long time in various forms. And this just says that basically the worker hasn't set up a business, set up a company merely to engage with that hiring entity. So, has the worker been around? Does the worker's business have a tail? Do they have other clients besides just the one client? Do they advertise? Do they make their services, publicly available at least to some extent? These are things that, again, have been around for a long time and that are fairly dealt with under many tests, including Borrello. B is where all of the fear comes in. The worker performs work that is outside the usual course of the hiring entity's business. That's the one that's got everyone quaking in their boots. That's the one. That's really the reason why we're here today, because this one is going to be the hardest to tackle. And you can move forward a little bit on this slide here, Holly. But what is the usual course of a hiring entity's business? hard to say. We're going to dive into that, but again, that's the one that's going to require the most work. That's the one that's going to be hardest, for companies to overcome. But keep in mind, now the burden is on the hiring company, and every single one of these three factors has to be satisfied, or you've misclassified the worker. So what are the things? What does this mean? Maybe the new test across the state. Again, we know that there's a lot of fear here. It could force reclassification of current ICs. So, before April 30th, when this decision came out, you had a crop of independent contractors, and everything was great. They would have passed muster at a judicial level. After this decision, they may be employees, and you have to deal with that. So that's one of the things we're going to discuss a little more, too. So what is a company like TalentWave doing? Without getting too far into it, right now we're aggressively reviewing our own process. We're working internally and with expert counsel to address what extent that we're going to need to accommodate Prong B specifically in this ABC test to our current processes. So there's no time for anyone to be resting on their laurels. With that, Holly, unless Neil has anything to add, I think we can move to the next. So here's a quote I think that sums it all up and speaks really well to the poll question that we took. This is from a law firm Ogletree. While the California Supreme Court sought to provide greater clarity and consistency by adopting the ABC test, in the short run, Dynamex is going to cause considerable uncertainty and upheaval. That's what we just saw from that poll question, and this is the new place that we're in, and this is why, again, there will be uncertainty until more of this gets interpreted, but it isn't the time to just sit and wait for the uncertainty to resolve itself. There are definitely actions that should be being taken. And with that, I think you can move to the next slide, Holly.
All right, and
We've
that
got
next
poll
slide.
question here.
Yep, it happens to be our second and last poll of this webcast. And so, post Dynamex, what will companies do about ICs in California? Folks, would you say that they would A, continue to engage a previously utilized? Would they B, use only when absolutely necessary? C, use but increase compliance and seek experts? Or D, just avoid ICs in California? So go ahead and submit those responses for us. At this time, we'll go ahead and move to those live results. And it looks like we've got a pretty good majority going for C, that they would use, but they would increase compliance and seek experts. So, Rob and Neil, what were you expecting?
I think you guys have been reading maybe you've been reading my blogs. This is what I would suggest too. I'm really glad to see that this is the result. So far, I'm glad to see that people aren't seeking to avoid independent contractors in California. That's not going to be the case. You're going to put yourself behind the eight ball, a competitive disadvantage. You're going to miss out on opportunities. But I can also see here, B is moving up a little bit, up and down. Use when absolutely necessary. Well, yeah. I mean, right now we're in a place where we really have to act conservatively until we get more case law on this. And then we're going to need to then perhaps change what we're doing later on. But for now, acting conservatively would be good, and that would include obviously working with some experts, working internally, having some oversight over your previous processes and things like that. Neil, any other thoughts on this one here, just from your perspective?
I think it's the smart thing to do. The size of B alarms me a little bit, only because I think that absolutely necessary is to some extent that ship sailed. We'll talk about this a little bit when we reach that section. But the reality is that best in breed companies have to leverage independent contractors. One of the takeaways in the BLS that we didn't talk about was the age and expertise of the typical independent contractor that declares themselves as an independent contractor. In general, they're older, they're more experienced, and they have very specific skills. And so, to be competitive, it's important that companies take advantage of that particular channel of resources. Right. So, I hope those folks that answered absolutely necessary really meant to succeed, as opposed to only when I can't find anybody else.
Yeah, and you have to think about what industry your company is in too. I mean, there are certain industries that traditionally use independent contractor labor, and it's going to need to be in California. Remember that a lot of this is going to be where the work is performed too. So you may have someone in Texas, but perhaps they have to come to your facility. Well, they're in California now. Or think about it. We may not have many participants from California's vast entertainment industry, but we can draw a corollary between that and other industries that really need to do business in California, and you can't pick and choose, such as the entertainment industry, where obviously all the many of the production and the performers themselves are paid on an independent contractor basis. Well, you're not going to be able to do much about that. So what happens there? Are they all immediately employees? So it needs to be, again, I think the wide majority of C is a good sign. You're going to need to use people here, but you're going to need to increase your compliance and seek expertise.
That's a good point, Rob. So for those of you who are thinking in the back of their mind, well, I just won't hire ICs in California. I'll hire them out of my Austin office. That's not going to help you much if the resource is working from home and lives in San Francisco.
All right, guys, let's go ahead and jump back to our material for the rest of this presentation. And so it looks like we're going to talk about this ABC test and its involvement with Massachusetts.
Yes, one of the things that we need to do is look to other states that have a similar test in place. One such state is Massachusetts. They have had the ABC test there for more than a decade, and they have some case law that California doesn't have because we just have Dynamex to look to. So if we're looking on at the state of Massachusetts, what we're finding is that the decisions haven't been as pro employee or more misclassification than we might be fearing about what Dynamex will do. There haven't been a whole bunch of cases to pull here, but we have gotten some guidance. The Attorney General in Massachusetts issued an order, a guidance to let people know a little bit more about Prong B, realizing that one seemed the most scary and that one seemed the hardest to satisfy. So for what it's worth, what we've got there is that usual course of business means necessary to the business of the employing unit or merely incidental. So that's the question you're asking. Are the services being provided necessary to the business of the employing unit, the hiring entity, or is it merely incidental to it? So that helps, but it kind of doesn't help. But it's more than we have so far. So how has that come out? How has that been interpreted? Well, it's been interpreted the way you might think. Newspaper delivery people have been reclassified as employees, and that seems to make sense. If you deliver newspapers, you're definitely not incidental to the hiring business there. They also have cases on such things as exotic dancers. Typically, they're found across all states and all tests as being independent contractors. So again, there's still no bright lines, but businesses in Massachusetts haven't stopped using independent contractors. So I just want to say that we're looking at other states, and what we've seen is that it's not as crystal clear as it seems. There are cases that you would not expect to have passed Prong B that actually have passed Prong B, and they've been held up as independent contractors. So one thing is we're kind of trying to read the tea leaves to see what's going to happen in California, and Massachusetts is going to be a good state to look to.
Rob, California's got a reputation as being rigorous in its pursuit of worker classification or misclassification. Is Massachusetts' reputation similar?
Very. Yeah, considered one of the hardest hardest states on misclassification. Absolutely. And again, as we've seen, businesses haven't stopped using independent contractors in Massachusetts. So there are ways to satisfy Prong B, to satisfy the ABC test, and that's going to be how it is in California too. And Neil, I've looked in some other states that have that use the ABC test. And honestly, there have been cases where it's come out independent contractor when you really wouldn't have thought it would have been that way. I've seen people who sell insurance held up as independent contractors, even though they're selling it on behalf of an insurance company. You would not think, reading Prong B as we have for California, that would have been the result, but it has been. So again, the suggestion is to act conservatively now, but wait, buy time. It may not be as bad as it seems.
The other question I had, or comment I had relative to this is this reclassification of large numbers of workers has ACA components to it too. One of the things that you have to do under ACA is provide insurance, or the opportunity to get insurance. Large numbers of reclassified workers will not have been provided that. And there's fines and penalties associated not just with core misclassification, but with sort of the ancillary things that go along with being an employee.
Sure. So some of the big things there is that you don't just want to go back and reclassify everyone immediately. You really do want to do your homework and see, do they need to be reclassified? How close are their services to what you do? If we were to Google your company, it's got to be a case by case rather than let's just take every IC we have and make them employees tomorrow. All right, so we've said all this, and I don't think that we've made anything much clearer than when we began. And frankly, we're not going to be able to do much of that because, as I said, we really do need to see more cases come through. But some of the things we can lean on and say these are some of the big takeaways would be, watch out companies that are similar to what we saw in Dynamex. So there are a lot of on-demand delivery companies. It's going to be really hard for those companies, or they're on wheels. They driving companies, the Ubers and the Lyfts. It's going to be hard for companies like that to make the case that those services the services being provided are not in the usual course of that company's business. So what we're seeing right now, what I'm seeing, is a lot of cases being pulled into court that are either other delivery cases, driving cases, things like that. They're coming back into the California courts because they want the plaintiffs there want to use the ABC test because it looks like it's going to be really hard to pass Prong B. So if you're one of these companies, these are the ones you've got to watch out, because it's going to be hard to say that we're not a delivery company or we're not a driving company under Prong B. It's going to likely wouldn't pass Prong B. The other thing is going to happen, and then this is what we were sort of talking about on the previous slide, was it's time to re-examine your current ICs right now. There will definitely be situations where you're going to need to reclassify the independent contractor as a temporary employee. And then all this goes away. I mean, that's the good side of things. Then all this goes away. You don't have to worry about the if. You don't have to stay awake at night wondering, wow, do I have this classified right? I hope nobody comes and knocks on our door and asks me. It's just done. But you're going to need to go in internally and find out, well, what is your usual course of business, and then start there. And if the worker is doing something that is really part of your usual course, and that's without a doubt, it's likely that you're going to need to reclassify them. But again, it's going to be case by case, and that leads into the wait and see. Right now, I'm getting cases sent to me that are being filed in California courts. I've probably gotten, since this case came out, about between 6 and 12 other cases that are going to the California courts, and that looks like, wow, I guess Armageddon is here. ABC is going to turn everyone into an employee. But it's actually a positive, because that means that the more case law, the more judicial opinions that come out, the faster we're going to see where this applies, what are its limits, where are its parameters, and again, it's all going to be around that second prong. So right now, I could say too that the trucking industry in California is already putting up a fight on the ABC test and trying to assert that it shouldn't apply to their industry. We're also, we're seeing it from both sides. We're also seeing cases come back into the courts, I believe for Grubhub. It's coming back into the court to be challenged again on the ABC test to see if it's going to apply retroactively, because that's a question that we don't know.
does this test apply to cases that have already been decided? Can I use it in reverse? That's a big question. We need to know that. Well, hopefully the Grubhub decision will make that more clear. Does it apply retroactively, or do I have to worry about what I did before, or just what I'm going to be doing from now? So again, we've also found out that the California courts have ruled that the ABC test shouldn't be used for joint employer. This is significant too, because the next question about independent misclassification, generally you're also wondering about joint and co-employment. A case came out that said this doesn't apply to joint employment. So these are things that we can kind of take from this case, and in the fact that we're going to get more knowledge sooner the more cases that are going before the courts. I'd say the last thing here is document at all times. If you're doing this, do more of it. If you're not doing this, do tons of it. You want to make sure that everything is papered up properly, because what you want to be doing internally is you want to build that sort of war chest, that defense mechanism should anyone come and knock on your door. Whether you want to do that independently, or probably more advisable to do that with some sort of expertise on the outside. That's what you want. Because at the end of the day, these are always case-specific. You can't be sure that what you're doing is going to pass muster. But the best way to do it is just defend it as best you can, and that would be with meticulous identification of the workforce you have, and then really painstaking paperwork on how the engagement is going, with the parameters and such.
So, Rob, the questions then, I think, based on that poll before, right? Is it safe to pay anybody as a 1099 in California at all? It is. But to your point earlier, Neil, the state's already tough on worker misclassification. In this state, we've got SB 459. And that's $5,000 to $25,000 per violation fines if misclassification is found. But it's not just about the money here in California. They've also got a requirement as well that if you are found guilty under SB 459 of misclassification, you've got to publicly post that misclassification on your website, or something that's really customer and public facing for a year. So it's kind of the scarlet letter thing that we have. So in a way, the ABC test just adds to how rigorous it is in this state. Again, it doesn't make it unsafe to pay someone as a 1099 in California, but you're going to need to follow the rules. And for companies thinking, well, everyone else is doing this, why not us? That's a really poor justification to not act in accordance with the laws and the case law out here, because as most of us know, these laws are enacted, paternalistically. Really, they're looking to protect, the little guy out there. They're looking to address inequity between the client company and maybe a small contractor. So just the fact that everybody's doing it isn't going to protect you if the government or a court comes to you and says, you're going to be the one that we're holding up to the light here. You don't want to be that first example out there. You really want to make sure that you're being as compliant as possible so that you don't become the person who has to post something on your website. So do follow what's out there. So the other thing that's coming up, and I think you addressed this a little bit, but as more court cases happen, we'll get a much better definition of outside the usual course of a hiring entity's business. But for now, to be conservative, we're going to have to assume much of what we wouldn't normally consider in scope to be in scope.
Yeah, and we're going to get a little bit more onto some brighter lines about how to satisfy the dreaded prong B. But one thing to think about there is that if what you're bringing someone in to do is something that, again, is obvious that that's the core of what your business is, then that's going to be something that you'll probably want to bring in on a temporary employment basis. Again, we say all this for now. There will be more to come, but we want to be cognizant of where we're at right now. Neil, I'm not sure that answered your question, so let me know what part of
that's good. That's good.
And then
from
the last,
yeah. Yeah, I was going to say from a other states' point of view, the obvious worry is that this will roll across the country like a tide. Any thoughts on that?
Yeah, it's so should companies be preparing for this to come across in other states? I would say no, but it's best to over prepare. I mean, obviously, depending on California, is sometimes seen as an outlier, frankly, right? Whatever the Ninth Circuit does out here is sometimes seen it's the Wild West, and no one else would think that way except California, right? So in that regard, it wouldn't be something that we necessarily would expect that the ABC test is going to roll out in other places. That being said, you want to kind of over-prepare because it's not that California is going to be seen just as a leader from this test. Part of it, what you're going to see, is that if you can satisfy the ABC test in California or Massachusetts, you can feel very comfortable that you're satisfying almost any other test out there because these are two of the most rigorous ones. So I think if you aim high, then you're going to be pretty protected across whatever ends up rolling out in other states. Yeah, this is again, we're hoping to add at least some hard guidance here in an unclear world, and with the caveat that more is to come. But if you're thinking about the ABC test and that second prong, Prong B, I've said some of this, but this will just clearly state it out for you. If your company can't exist, it can't subsist without the services being provided, then those services are going to clearly be in the usual course of business. And that doesn't mean that, this one person does something that no one else can do. It means if it's something that is just, you're a software development company and you bring in a software engineer on an independent basis, this is likely would fail Prong B. So if you need the services, if they're that integral to your company, if they're that core to what you have to do, then right now what you want to do is bring them in on a temporary employment basis and not as an independent contractor. I think commensurate with that comes along with that is if the services provided are included in your company's name, your advertisements, it's most likely going to be the usual course of business, and you're going to want to avoid using that person as an IC. So there are some times where we have where we see companies, they may come to us, and literally it's in their title that they perform some kind of service, and then they want to bring on contractors who perform just that service. It's in the name, and it's in the contractor's engagement description. In that case, it's way too close. It's gonna really you're gonna run afoul of Prong B. So that's another thing to keep in mind. A couple of the other things that may be a little more discouraging, but you just need to be aware of them too. Think about how regular the activity is. This goes back to some of the best practices that are already out there, such as how long is the engagement? Is it endless? Remember, independent contractor engagements are really supposed to be project-based. Are they? I mean, we see out there that project-based could mean we renew it every year for the last 10 years. These are the kind of things that, from a best practices perspective, even before Dynamex, you really don't want to do. You want to use that person on a project basis. We see it done, and sometimes it's in a compliant fashion. But post Dynamex, if you have something that's going to be on a regular schedule, even if they're infrequent, but every 3 months you bring this person back for another 3 months, and they keep coming back and coming back and coming back, that could be seen as usual course of business too, even though that's not having any. It may not have anything really to do with what's the title of your company is, or if I Googled your company, what that description would be. So really look at how regular you're using, how consistent that is, and it may be the kind of thing where, again, project-based is going to be more compliant all the time if you compare that to somebody who's just open-ended coming in. All right, and then kind of goes with the third one too. So it doesn't need to be strictly your sole principal or core business. It goes to, again, the frequency, right? How often they're there, how long have you used them. So even if it's outside the usual course, there is some case law. And where am I getting this? It could be a good question too. We're working with our own counsel. We're reviewing cases from other states. We're looking at how California also has interpreted usual course before Dynamex. That doesn't mean that's how it's going to be interpreted after Dynamex, but we're doing everything we can to get ahead of how it could be interpreted. So you really want to think two things. Is it just obviously what you do? Just ask yourself what you do if you were to Google yourself, what do you do? Well, if the independent contractor is doing that, it's not going to be an independent contractor under Dynamex. And then again, keep your things, definitely project based, because the regularity could add into running afoul of Prong B as well.
Thanks, Rob. So on the next slide, we have some examples and context. So I think it'd be helpful if we went through these. So what we wanted to do was provide you with the scenario, and then that scenario applying in three contexts, so that might help you understand what it really means. So in this case, we're looking at an expert in international tax. She does all the things a small business does, right? Pays her taxes, provides her own work product, designs her own methodology, has multiple clients. And then we're going to provide sort of three contexts, working from clearly safe to clearly problematic. So if she's providing advice to a company that does not provide accounting and has no internal tax department, no internal accounting department, it's probably okay, right? As long as the other elements of the ABC test are appropriate. In the middle is this sort of problematic. I have a department that does what services she's providing, but it's not my core business. And that's when you have to really get underneath it and start thinking about what are the other elements of the test, and how strongly she passes those elements. And then on the far right, the clearly risky problem of a company whose services are very similar to this independent contractor services, very often provided to their customers. And in this case, she's advising the firm on tax practices, just like they advise their customers on tax practices, and that becomes a very likely W-2 ruling. Rob, you want to weigh in on that?
Yeah, and Neil, on that last one, clearly risky. I mean, this is when you need to put into there your recent retirees, people who were doing things for your company for a number of years and just left, and now you want to bring back that expertise because they worked for you for 30 years and they know things that no one else knows, but they've moved off into the sunset now. This is the kind of thing where you need to think that it's clearly risky, right? So one way around that, if you're gonna try to move in a compliant way, is just we need to make sure that people actually have a business doing what they're doing, right? Because that's the same way that it's going to be looked at here, and that speaks to Prong C, because as Neil said, we're talking about Prong B because that one is the most difficult, but you do have to you've got to satisfy the other two prongs too. So you don't want to do things because it's convenient. Okay, you don't want to engage with people because you want it to be 1099 and they want it to be 1099, because the law that's not what they're concerned with. The law is for rooting these things out because the law feels that it's inequitable, or it's hurting the competitive advantage for people doing it correctly. So you want to make sure that you're not that you're taking all the appropriate steps there. And it's not just working. I mean, I'll add this one note too, that even in Dynamex, the primary plaintiff in the Dynamex case did sign an independent contractor agreement. So there was one signed. So if you're thinking, well, we've got an independent contractor agreement and this person signed them and we didn't hold a gun to their head, well, that person in Dynamex also signed an independent contractor agreement. A few months later, decided no, this isn't fair, and now we have the ABC tests in California.
Yep. All right. Thanks, Rob. So just for a second here, let's move on to the next slide and reiterate sort of what we've done internally and obviously what we're advising you guys to do internally. So we've been working, as the firm that we have inside counsel, but we also rely on outside counsel to some extent. So we've been working with them to get a clarification of what they perceive the current snapshot of normal course of businesses, making efforts to modify internal process on behalf of ourselves and on our client. As Rob pointed out, we don't know what we don't know. So in the meantime, we're going to take a more conservative stance than we might have otherwise done. So regardless of all of that, recognize that it is different than it was a month ago, and that you need to re-examine your processes and your individual classifications as well, just as we are doing. So I wanted to sort of end this, take a couple of minutes to talk about sort of what isn't different, what hasn't changed relative to the way we all have to handle our talent acquisition process and really just managing how the work gets done. So, look, at the end of the day, we still have to deliver value to our customers, and so we still need to access and retain the talent that we always needed to do. And it doesn't matter that it's harder now. We still have to. We still want to achieve significant cost savings on behalf of our customer. Holly, you can just keep advancing. On behalf of our customers and our internal and external customers. This is an aggressive economy, and change is happening quickly, and we need to be flexible in our delivery. We need to continue to standardize. We still need to develop methods of worker engagement, regardless of how they are engaged, and recognizing that sort of even outside of California, worker classification as an issue is simply not going away. Finally, just to reiterate our point of view of the world. Flexible workforces, on the next slide, Holly. Flexible workforces are important, and it's how best-in-class companies continue to perform. We still need those on-demand skill sets, especially if they satisfy Prong B, right? That almost literally means that that's not what we do, but we need it. It is more expensive to engage a full-time employee than it is to flexible workforce, independent or not. There is efficiency in having more than one resource compete for the work that needs to be done. As hot as the economy is now, it will be at some point in the future less hot, and we'll be able to scale up and down against that demand. And really bringing new and smarter people into the organization at various points in time and projects is an important way to advance the overall competence of a given organization. And as we've mentioned in the past, it's cheaper, better, faster than sort of the large external consultancies. So these flexible models matter, even in light of Dynamex. So that ends the formal presentation. But Rob, you want to give your point of view as well?
Yeah, just on that, let's keep in mind that even in the BLS report, I think it was over 79% of the independent contractors that they surveyed there preferred this type of engagement to any other type of engagement. So the satisfaction level with independent contractors is still high. So there's still the desire there for them to be used that way. Yes, that doesn't really matter too much to the law. They might step in, but good to note that you're going to still have those scarce and talented resources that want to be engaged this way. So let's continue to find a way to do it compliantly.
All right, guys, thank you so much for all of the information on Dynamex and giving some companies an idea of what they should do. At this time, we'll go ahead and jump into some questions and answers. We've got about 10 minutes left. So folks, if you have not yet submitted your questions, please go ahead and put those into that Q&A box that you'll find underneath the video player. So guys, our first question comes from Joanne, and she asks, are companies reviewing internal job descriptions to ensure separately categorizing work internally versus contract duties, and should they be?
It's a good question. I think sort of irrespective of the Dynamex ruling, that's a good practice regardless. But Rob, do you have a perception of that as in terms of a compliance effort?
Yeah, and I want to make sure I answer. That was a good question there and a lot there. So let me know if I'm not speaking to what that is. But generally speaking, you do want to keep the two things separate. You would like to review all your job descriptions, everything, and make sure that it sounds like an independent contractor engagement and not not the job posting for somebody that you're going to hire as an employee. So even the words, the verbiage, all that should be looked at too. I mean, we get cases where an independent contractor agreement makes a lot of references to employment. And then we have to weed those things out because you just set yourself up for an issue. So, not sure if that speaks to what that question was getting at. So feel free to resubmit that one or ask for clarification.
All right, sounds good. And then our next question comes from not Joanne, but Joanna. And Joanna asks, what states use the ABC test and which ones do not? She asks, if you are an employer across the U.S., what do you recommend?
Yeah, so some of the states that use the test are New Jersey, Vermont, Connecticut, Massachusetts. And different versions. I mean, the one thing about that Prong B that really hurts right now, that is causing pain in California, is that it's got only one way to satisfy it, while other ABC tests have that Prong B has two ways to satisfy it. So while here we can satisfy it only if we show that it's outside the usual course of business, in other states their version of Prong B includes an or that all the services are being provided outside of any of the hiring entity's facilities. So you've got this on-site, off-site piece that could take care of B, which we actually don't have. So I think I wanted to mention that as well. But yeah, those are some of the states. And the second part of that question, Holly, I'm sorry.
Yeah, second.
Before you move on, Rob, just one more comment.
Yeah.
The other thing is that the ABC test is used by something like 2/3 of the states, but it may not be being used for wage and hour. It might be about unemployment, or it might be about workers' comp.
Yep, true. Good point.
All right.
There was a second piece to that question, Holly. I want to make sure I didn't want to miss anything in case I did there.
Yeah, sure. We'll cover it just in case. Joanna asks, if you are an employer across the U.S., then what do you recommend?
From my perspective, I recommend complying with the most stringent, strict standards, because everything underneath will be taken care of by that. So I'd aim high. I would try to satisfy Dynamex, even if it ends up not being used statewide. If you can satisfy Dynamex, there's going to be a good chance that you can satisfy anything. But let's not lose sight of the fact that the good old IRS 20 factors, that is still the federal test there for taxation purposes. That is the one that has the most legs, and that's still something you really want to satisfy. And that's that direction and control and all those factors. Again, I think if you can handle the ABC test, you could probably handle that too. But that's something to keep in mind is ultimately misclassification in a lot of ways has come down to a huge tax gap. So you don't want to lose sight of the good old IRS, who's going to be coming in looking at those common law 20 factors.
All right, thanks for those answers, guys. Our next question comes from Johnson. He asks, how do you think this might play out for nonprofit and governmental organizations? Good question there.
Well, I mean, nonprofits, still have to comply with with the same things. So you still have to comply. Neil, I don't know if you had anything to add there off the top. I heard you.
Well, it's interesting. So the governmental entities, your primary danger in a governmental entity is not, not an outside audit from a worker classification point of view, but it is identical, and in fact the same sort of seed problem as Dynamex. Workers can form a class if they perceive their rights as workers are being violated, regardless of what kind of entity it is.
Yeah, that's true, and there are cases that I've come across too of a contractor at a state agency who brought a claim against that state agency, for misclassification. So to Neil's point, it's not always going to be another state agency that's coming after another state agency, but the risk is still real because. Just because the state agency doesn't mean that they're classifying these people properly, so the risk would be coming, often from the contractors themselves who are saying, "Hey, I'm sitting in here, sitting right next to a whole bunch of people who are employees, and they're pretty much doing the same thing as me. Why can't I come to the holiday party?" And then something happens.
All right, thank you for that answer. Next, let's address a question from Allegra. How significant is the organizational structure to how independent contractors are classified? For example, structures where ICs report to supervisors, then go through training, etc.
Yeah, don't do it. I'll leave some room for Neil here, but you think of your independent contractor as somebody you don't have to babysit in any fashion. Maybe you got to get them badged up and sign an NDA and all that, but you've got them because they already know what to do. So to the extent that you have them reporting up to anyone, shouldn't be doing that unless we're talking about status reports for things that are written, and they should be written into your ICA, your SOW, really, and negotiated. But you should be looking at that independent consultant as somebody who is ready-made to do the job. When it comes to training, you don't want to be doing any training with them because, again, they're supposed to have those things. I think the only thing you can think of is if the training is just around perhaps a client company system that they wouldn't expect to know just coming in, that's a little bit different. But if we're talking about core training to perform the services that you're contracting with them to do, then don't.
Do you have any comment on the reporting structure? I mean, you need to have someone. I mean, somebody bought the service from the IC, so I don't perceive that as a major problem. If the reverse, I think it's a big deal. You should not have your ICs supervising your own core staff.
So again, when we're talking about reporting, what we're really talking about there is what's the nature of that reporting. Checks and balances, are they reporting on updates around the deliverable that they're providing? Okay, this should be fine. Do they have other reporting requirements that are required, and they didn't get a chance to negotiate that up front on what the reporting requirements are going to be? That might be more of a problem. So just think of it in terms of, well, is the reporting something that you might do with an employee, similar to that, or is reporting really tied to what the services are? And as far as in reporting to someone or calling in, Neil, yeah, that this is likely right. Everything's case by case. That's fine to have someone to report to, but you really don't want it to look like similar to how you would have in an employment relationship, if that helps.
All right, guys, thank you. So I think we'll have time to squeeze in just one more question. We've only got a minute or two left, but let's get to this question from Kathleen. She says, we often hire 1099ers, 1099ers due to the same work that we do because we have a backlog of consulting work. Is there an issue here with the three-pronged test?
Yeah. Rob, you want to elaborate? But I perceive that to be a pretty big problem.
Yeah, and I'm sure you could. Yeah, this one you can speak to as well. But that's so you don't want to have 1099s doing what regular employees are doing, and you don't want your 1099s to be being paid on a 1099 basis when they're actually staff augmentation or something like that. Those should be temporary employees because they're performing the same or similar services that regular employees are doing. So by that very nature, they're not going to be viewed as an independent consultants. And Neil, feel free there.
Yeah, I'm alarmed a little bit by the context of the question in which they're performing work on behalf of that person who asked its customer in the same manner as core employees, and I think that's very problematic in my mind. It's not impossible to provide services to your customers through an IC, but it can't be identical to what your W-2 employees already do.
All right, great point to end on there, guys. And so we do have some remaining questions. We'll make sure those get passed on to our presenters so that they can follow up with you at a later time. Just a quick reminder, today's webcast has been approved for HR, CI, and SHRM credit. You'll find these credits for attending today's webcast if you'll go to your My HCI profile and then hover over that drop-down menu to My Learning Journey. One more huge thank you to TalentWave and, of course, Rob and Neil for today's presentation. And for all of us here at HCI, thanks for being here. We'll see you next time.